Good evening, everyone. Thanks so much for joining us today. My name is Melissa Murray, and in addition to being a law professor at NYU School of Law by day, I'm also a member of ACS's Board of Directors and its Board of Academic Advisors, which is sponsoring tonight's program. This is our second virtual book club meeting, and if you haven't joined us before, the idea behind this event is to collectively read a book concerning important issues of law and policy and to hear directly from the author. After, we will break into facilitated small groups to further discuss with each other the themes of the book and the topics covered within. Before I turn to our featured speakers tonight, I want to offer special thanks to our breakout group facilitators. University of Chicago law professor Aziz Huq, who is also a member of ACS's Board of Directors and the BAA. Harry Littman, a former US Attorney and Deputy Assistant Attorney General, who is a regular commentator on television and host of the Talking Feds podcast. University of North Carolina law professor Bill Marshall, who's also a member of ACS's BAA. Georgetown University law professor Victoria Norse. ACS's Director of Policy and Program, Deborah Perlin. Judge Shira Schindlin, a member of ACS's Board of Directors, who was appointed by President Bill Clinton and served for 22 years as a federal judge of the United States District Court for the Southern District of New York and is now counsel at Strzok. And Mia Woodard, a legislative affairs and policy counsel at Citizens for Responsibility and Ethics in Washington, otherwise known as CREW. Tonight, we are joined by Andrew Weissmann and Elie Mystal. Elie is known to everyone as the voice behind Above the Law, and also now as the nation's justice correspondent, covering the courts, the criminal justice system, and politics. He's the force behind the magazine's monthly column, Objection. Andrew Weissmann, who's the author of tonight's book, Where the Law Ends, is the co-chair of Jenner & Block's Investigations, Compliance, and Defense Practice, and my colleague at NYU Law, where he's a distinguished senior fellow with the Center on Administration of Criminal Law. From 2017 to 2019, Andrew served as the lead prosecutor in Robert Mueller's Special Counsel's office. And from 2011 to 2013, he served as the general counsel for the Federal Bureau of Investigation. His book, Where the Law Ends, Inside the Mueller Investigation, is a riveting account of a most difficult chapter in our nation's history, which the Washington Post said burns like an old-fashioned 150-watt bulb, delivering light and heat in equal measure. In addition to writing books and teaching classes and working at Jenner & Block, Andrew is also a commentator on MSNBC and a notable feature of Rate My Skype Room's top 10 features, where he is also my turtleneck rival. So I am delighted to be here today to introduce two of my favorite people in conversation with one another. I will let you all take it away.
Thanks so much, Melissa. And Andrew, thank you for this book and thank you for writing it. Thank you for doing this work. It's a fascinating account of what went down during our long national Mueller nightmare. The first question I want to ask you, I mean, the book, the fear that you guys faced was palpable while reading this book. And I don't just mean that from, you know, my days as an associate at Deborah and Plimpton, where I was on the other side of the V trying to defend myself from you people. Like, that was there too, but the fear that you guys had of being fired, of your investigation being shut down, it goes through all, it's infused in all of the pages in this book. And so my first question is, what is your advice for lawyers who will face this in the future? Because sadly, in part because of how Republican politics is playing right now, in part because Trump's strategy worked, and the fear did, in some way, halt, or at least, distracted from the pursuit of fact. Because that strategy worked, I imagine it is a strategy that politicians in power, politicians facing public corruption charges, will employ again. So what is your advice, having been through this crucible of fear, to other lawyers who might one day literally be in your shoes?
So I think there are a number of things that I would recommend. But first, thank you so much for having me. I really look forward to this conversation, and it's wonderful to be doing it with this particular group. I think there are a number of ways to answer that. Taking it the most granular level, so from just an individual point of view, I think you have to be pretty fearless and have a tough skin, and just be willing to hunker down. We were very lucky in having Robert Mueller to keep an even keel and keep us very focused on our work, and to not have to worry or get distracted by things. That's sort of on a sort of very narrow level. The bigger picture is I think you kind of need to be fearless in decision making, and it's difficult, but I think one of the things that I think everyone can learn from this experience is that the current special counsel rules really need to be changed. I mean, there's some people who think you really have to go back to an independent counsel rules that existed, post Watergate. I'm not there yet, but it's, it may be that that's really needed if you are going to, again, face a sort of autocratic presidency and a attorney general who doesn't view himself or herself as independent of the Justice Department. But I think there are a lot of other things short of that can be done. One of which is, I think that the special counsel rules need to be clear, not just about things like being able to give things to Congress at the same time that we give things to the Attorney General, but that there is an educational function of the special counsel, and that there is more communication with the public about what exactly we can investigate and what we can't investigate, and the public education function about any report we issued. I think that was something that was lacking both by Department of Justice leaders, as well as I think we could have taken it on more. But the special counsel rules themselves actually don't encourage that. If anything, they discourage it. So I think there's a sort of multi-layered answer to all of that. I don't think at the end of the day, although I think of myself as a bureaucrat and an institutionalist, I'm not sure any of this will prevent another Trump-like president, but I do think that there are structural things that can be done that will make it easier for the next special counsel or independent counsel to operate.
What do you say for people? I mean, certainly when I was reading, at one point in particular, when I got to the Ivanka section, I had to put the book down to scream at my wife about what happened here. When you talked about how, I think the exact line was, Ivanka never turned down our request to interview her because we never asked. And that was just like, like how should we understand that as the general public? And I guess the way I want to shape this question is, do you think that it was better for the general public that you kind of went through this process as best as you guys could within the constraints that your office felt it was operating under? Or would it have been better just to kind of shoot for the moon, and if he shuts you down, he shuts you down. If he shuts you down after a month and a half, he shuts you down. But you pursue the truth as bravely and as diligently as possible, as opposed to making some of these deals, not even deals, making some of these concessions to what I think you guys were probably right, what would have been a strong overreaction and possible shutting down the investigation by the previous White House.
Yeah, this is the issue of our self-censoring. And, when you self-censor, you have to accept the criticism of, and the decision-making behind that, for good or bad. And I think the Ivanka thing has gotten a lot of attention. I actually think the full financial investigation is sort of a bigger topic because we ultimately did not do that. My view is that, just so people understand, I'm not just blaming other people. I initially thought that we were correct to pull some of our punches as we were getting off the ground. And I tell this story about how we issued a subpoena to Deutsche Bank, and the White House heard about it and asked us, who are we subpoenaing and why? And are we crossing the red line of subpoenaing the President of the United States' financial records, which he had publicly said would be a red line. And, you know, in a normal investigation, you would say to your target, like who the hell are you kidding? That's not the way this works. You know, as everyone knows, if they've been on either side of the V, as you point out. But here, we had two huge challenges. One that you don't have when you're facing any other target, which is the person can fire you and the person can dangle pardons to change the calculus of obtaining cooperation. And at the outset, before we had made a case on Manafort, before we had done the Russian investigations, before we had information about the Trump Tower meeting, about Roger Stone. I mean, there was just so much information that we did gather before we knew what Trump was doing to obstruct our investigation with Don McGahn. I thought it was correct to, and for good or bad, I mean, people may disagree, at the outset to decide, you know what, it's not worth at this point crossing that line, and we can do it later. Let's investigate further. Where I do disagree is I think that ultimately there were decisions that needed to be made, and one of the refrains that Jeannie Rhee and I had with a lot of the FBI agents was, you know, better to get fired. Meaning, at some point, exactly as you said, it's like you just make the decisions, and if it turns out that you're fired, you're fired. We had taken substantial steps by that point to preserve everything we had that I sort of outlined. We had very early on were aware that we could be fired at any moment, so we had a number of ways of making sure that that our records and what we had found would be extant. So I think that was, to my mind, that was the issue, is that we, places where we had pulled back initially, we did not revisit that, and which is something, as in any investigation, people have different views, and I had a different view as to how we ultimately should have handled those things.
I have a question, and it goes to your point, and the point you make a lot in the book about the pardon, the unique pardon power of the president. Having gone through it, hindsight being 2020 as it must be, do you have a different sense on just the strategy of trying to flip people? Just knowing that, you know, trying to flip people when the target can literally pardon them is just a fundamentally different kind of game. And B, kind of whether or not the law needs to, the prosecutorial side of the law needs to develop kind of other fact development structures beyond flipping. I mean, I feel like you make a very compelling case in the book for why flipping is critically important. And you go into your history prosecuting the mob to talk about why flipping is so critical to investigations. As a person who's, you know, spent some time in criminal defense, or at least white collar defense, it's like, well, flipping is bad. You're putting enormous pressure on people who you and I both know aren't the people you're after, in order to get them to I don't want to use the word rat, but, you know, in order to get them to share truthful information about their friends. Is there, so A, do you think just the strategy in this particular case of trying to flip people could have, you know, was there a different way to go? And B, do you think in general prosecutors need to find different ways of getting at this evidence other than relying on, you know, weak links to flip on their cohorts?
You know, I'd love to say that it's useful to come up with other ways, but, you know, there are only so many tools, and one of them is cooperating witnesses. You know, having done organized crime cases, worked on the Enron investigation, having an insider is critical to being able to make those cases. And so it's great to say, yes, it's wonderful to get a Title III, an electronic intercept, to have it through surveillance, all sorts of other ways. That's great if you can do it, but for most historical investigations, that's not going to happen. You really do need an insider, and so that traditional technique is one that I was a big fan of trying to use. So was Robert Mueller. I think one thing, obviously, there's a whole constitutional problem here because the pardon power is exceptionally broad. So it is difficult to say, oh, here's the remedy without a real constitutional fix, which isn't going to come anytime soon. One thing that could be done, and this is a hindsight is 2020, is trying to push the courts more and bring cases where we thought that the use of the pardon power was to obstruct justice. In other words, to bring the challenge that this is what is going on, to try and thwart that process and to thwart people who might be enabling that process. In other words, assuming that you have people in the White House counsel's office or private counsel for the president who are ethical or concerned about their roles, that I could see pushing that in the appropriate case. So one of the things I like to say about the fact that the president was dangling pardons is there may be legitimate reasons to grant pardons. In other words, you can think of illegitimate and legitimate reasons, but it's hard to figure out a legitimate reason to dangle a pardon to Paul Manafort while the jury in his first criminal case is out, and to try and send the clear message, which is if your lips stay sealed, you'll receive a pardon, which in fact is what happened.
That's exactly where I was going to go next. So I just want to highlight how much you call this. In your book, you say that the actual prosecution of Manafort actually kind of didn't work out. The hung jury for Manafort didn't work out for him. You said that better he receive a flat-out acquittal or a flat-out conviction. Now he could face prosecution on state charges on the hung charges. It left Manafort exposed in a way that the president did not have the power to fix for him. Just recently in Just Security, you wrote this entire article about the pardons for Manafort, that now that they've happened, the weaknesses of the pardons. You pointed out how, for instance, the pardon for Flynn was actually quite broad. He probably got Flynn off, but Manafort was either through incompetence or whatever, really quite narrow, and it doesn't fully help Manafort. Can you kind of explain to people how you see a way for Manafort specifically to still be brought to justice?
Sure, and this is true for anyone who received that type of pardon. So, the president has a very broad pardon power, and one of the things that he certainly can try to do, as he did with Michael Flynn, is pardon not based solely on actual charges that have been brought, but pardon for the underlying conduct, meaning no matter how the government tries to slice and dice the criminal charges that could emanate from that conduct, I am granting a pardon. So, and in fact, in the Flynn case, it went even further and said anything that's sort of remotely in the special counsel's jurisdiction, I am pardoning. I mean, it was just, somebody was just like, with heaven and moon and the sun or what's being pardoned. So that's the broad view. The narrow view of a pardon and wording is if you have a pardon that works in essence like a commutation. A commutation is just saying you're not going to do any more time, jail time, for this particular crime that you've been convicted of. You're now released. So in Manafort's case, the pardon worked by a pardon of the crimes charged. So to your point, in the Eastern District of Virginia, he was found guilty by a jury of specific charges, but there were hung counts, meaning there was no crime of conviction there. And those are crimes that not only are there's no double jeopardy as to his having been convicted. But in the course of his pleading guilty in Washington, D.C. a month later, he admitted all of that criminality. In other words, he actually had to say as part of his plea agreement, I did all of those things, even though I haven't been convicted of them. So at this point, because he breached that plea agreement and the court has found that, the new Department of Justice can both look at any crimes that he has not been pardoned for, and they can look at the quantum of proof they have, which in this case is an admission under oath signed by the defendant, if they were seeking to continue to prosecute him. One of the things I note is, well, Manafort has done just under 2 years of jail time for a sentence that he received of 90 months. He didn't even qualify for the COVID release that he obtained because the Bureau of Prisons gave him a COVID release outside of the norms that they had created for everyone else. So he has been the beneficiary of a lot of largesse from the Trump administration.
Can I ask you, and I don't want to be all Phil Donahue on this, but how did this make you feel?
We're dating ourselves.
Seriously. How does this make you feel? I'm reading this book and it's, you're the head of Team M. You're the guy who spent 2 years trying to get this guy. You got this guy. And then the president, and again, you anticipated in your book, but then for the president to let him off the hook, or try to let him off the hook, on his way out the door, like just emotionally, what was that like to kind of go through?
So I don't want to sound like a Pollyanna on this, but the Manafort pardon, like the Stone pardon, was so anticipated that it wasn't like I was, shaken to my core. My first reaction had to do with the nature of the other people who were pardoned. My old office in the fraud section had prosecuted Philippus Formus, the single largest healthcare fraud individual ever, over $1 billion of fraud in Miami. There were corrupt politicians. There were civil rights violations. There were people who actually murdered people. I mean, there were so many. It was a rogues gallery where you couldn't even. I mean, if you thought that Mark Rich was a problem, this was Mark Rich on steroids. It was just so unbelievable that these people would receive pardons when there's so many deserving people. To channel NYU colleague of Melissa's mine, Rachel Barco is a huge fan of the pardon power when exercised appropriately to provide some measure of compassion and justice. This was the antithesis of that. And one thing that I was very useful for, and this is one where I'll take a little credit, is there were a number of things that we built into the Manafort plea agreement to try and mitigate these concerns. So there were state charges that could be brought that were protected, and we got admissions from Manafort so that could help a state charge. We, in doing the forfeiture, had him agree that this was forfeiture that could be brought civilly and criminally. The reason for that is that you cannot get a pardon for civil liability. So we were thinking ahead to ways in which there really would be just punishment, even if the president did what he did.
Do you think there's a will to do that? Do you think there's the will to go back and get this guy?
So I thank goodness I'm no longer inside the Beltway. And, I don't know the answer to that. The one thing I will say, I'm a huge Lisa Monaco fan. And I think that she deeply is concerned about the rule of law. I don't know Merrick Garland that well, but I also am a big fan. And I think that judges may have a greater ability to really think about precedent here and the need to uphold the rule of law long term in terms of whether it means investigating the president or holding people to account. And there really is a way now for the department to take action. And whether they do or don't, I think that it is incumbent on them to have to explain to us what their actions are. If they're going to say, no, we're not doing it, I think they really have to step up then and explain why they're not.
I want to get you out of here on the OLC memo. You talk about how you were bound by it. I appreciate that, in the moment, given your mandate, that you had to be bound by it. Do you think this is a good thing? Do you think that essentially leaving the decision of whether or not to hold the president accountable to the law should essentially be, as we saw during the impeachment process, left up to the president's own political party? We've had a number of presidents impeached. We haven't had any of them convicted. Doesn't look like we ever will. Quite frankly, I mean, if this didn't do it, what would? Do you think that the OLC memo can apply if there is no other way to hold the president accountable?
And just to add to the problem there is, one of the things that we hear now is, well, we don't want to move backwards, and the Mueller stuff is old news and it was dealt with. Well, at the time, the president could not be charged under Department of Justice guidelines, and the special counsel is currently is part of the Department of Justice. So it couldn't happen contemporaneously, but now that he's out of office, people are like, oh, let's move on. What that leads to is a view that the president is de facto above the law, even though the Supreme Court has said, no, he's not. So, I mean, there really is a structural problem in not being able to capitalize on the issue at the time. I think that the two OLC memos, obviously one written under the Clinton administration, one written under the Nixon administration, go figure, and say that, an OLC says, surprisingly, no, you can't indict my boss. Those are not the most well-written, well-reasoned opinions, and they're not really sort of a magnum opus. There's no judicial decision on this. There were a couple district court cases that relatively recently cast doubt on the reasoning, which is why I'm doing the same. So obviously there's a legal issue. I'm a big believer in that should go to court. I mean, we're in this limbo right now where no court has actually ruled on this. I understand why testing the law was maybe not front and center of the special counsel investigation, but that was an opportunity to get something in front of the court to address. And I think it has to. We unfortunately don't, in this case, don't have a situation where, as in other Western countries, where you don't need a case or controversy to get a ruling. And this is one where we really do need to have the court weigh in on this to decide what can happen. I'm less concerned as a practical matter of the Department of Justice having the ability to indict a sitting president, and I'm a little more concerned if any state could do that, just given the havoc that could result in. But I ultimately think we have to be able to get this to court and have a decision one way or the other, and then deal with it if we think it's incorrect.
Exactly. You say you even called yourself just now an institutionalist. I think this goes to the question of are our institutions capable of holding people accountable who don't play by the rules, essentially? Like the institution the institutionalism kind of works if you assume that everybody else in the institution also kind of sings out of the same hymn book. But when you have people like Trump, when you have people like Barr, quite frankly, who ended, I wouldn't put, of all people, I wouldn't put Don McGahn in this category somehow. But when you have people like Trump and Barr, how is an institution supposed to survive people within the institution who don't believe in those institutional rules? I guess is the question.
Well, one of the reasons I wrote the book was to have people start thinking about the special counsel rules as at least one aspect of the very difficult issue of how do you hold the executive branch to account when there's criminality. And and frankly, thinking of it, what do you do short of reimposing an independent counsel rule? Not that that's necessarily the wrong way to go, but I also think that that might be a lot harder to do. And I went back and reread portions of the 9/11 Commission report because I thought it was so exceptionally well done, because they were dealing with the same kind of issue of how do you get institutions to sort of step up and take ownership, and how do you create structures that are going to facilitate reducing the risks of another 9/11. And I think that is an area where, we have seen a complete dearth of sort of public engagement on this or congressional engagement on this issue. It'll be interesting to see now that the Republicans are not in the majority, they may suddenly be more willing to come up with ideas as to how to rein in the sort of imperial presidency. Now that they're no longer, it's no longer their imperial president.
Thank you so much. I think it's 4:30, so I think we have to do the breakout. Kara, are you
Yes.
down for that? Thank you so much, Andrew. Again, thank you so much for this book. It was a fascinating read, a real inside baseball account on this kind of, just rolling, I feel, tragedy that we've been through as a country. The insider perspective, I think, is invaluable. So thank you so much for that.
You're welcome.
Thank you, Elie, for leading us through that conversation, and thank you to Andrew for joining us. So I'm Kara Stein. I'm the Vice President of Policy and Program at ACS. Thanks to everyone for joining us today. We're going to break you out now into smaller groups for discussion.